Hello friends, so I am back with my new lecture, that is the provisions in the constitution and the law about the disqualification of MPs and MLAs. So in the last lecture I have discussed about the candidates who want to fight elections. If they are confined to prison, they cannot vote but they can fight elections. So now it's time to discuss what are the provisions in our constitution as well as law by which the MPs and MLAs or the persons who want to fight elections, they can be prevented, and those who have become MPs MLAs, they can be disqualified. Provisions in the constitution and law we will be discussing. Now our constitution has mentioned some of the points, that if a person holds any office of profit under the union or state government, so definitely कि if any office of profit has been occupied by the person, then he cannot fight elections. Or if the person has been found to occupy MP or MLA, found to occupy the office of profit, he will stands disqualified, he or she stands disqualified. So any office of profit is being occupied by a person seeking to become MP or MLA, or if he has become MP or MLA, he stands disqualified. So office of profit, you already know that the any office which yields profit to that person. Now this in this office of profit, the post of minister, governor, office of minister, office of president, governor, so these type of offices are exempted from the office of profit. So if you hold any office of profit, like for example the post of secretary to the government, so that is the office of profit from where for the post of those offices जहाँ पे the salary has been given from the state exchequer or state exchequer. So except the office of the president, governor, or the ministers. Okay. Now first point is this. Second point is if he is of unsound mind and stands or declared by the court. So unsound mind, you already know the mind, unsound mind, that the mind has the person is not behaving, so person behaving like a lunatic, for example. Okay, a person is not able to understand the functionality or the responsibilities of the post on which the post the person is occupying. The person is drunk, or for example he is out of the mind, so that is unsound mind, still not defined in our constitution, but that is being subjected to interpretation of the Supreme Court or the courts, but the person is behaving like a lunatic, so that is of unsound mind. Third, if he is an undischarged insolvent, means he has some debts which he is not unable to pay, so that is an undischarged insolvent. If he is not a citizen of India, okay, he is a citizen or voluntarily acquired the citizenship of a foreign state, so the person stands disqualified. And if he is so disqualified under any law made by parliament, तो अगर parliament ऐसा कोई कानून बना देती है तो वो भी disqualify होता है. So due to this last point, Parliament has included some more provisions for disqualifications of MPs and MLAs in RPA. So Representation of People Act 1951 में जो कि कंडक्ट ऑफ इलेक्शंस के प्रोविजन जिसमें डिफाइन किए गए हैं, तो इसमें MPs और MLAs के डिस्क्वालिफिकेशन के भी पॉइंट्स डाले गए हैं. ये हम प्रोविजन फॉर डिस्क्वालिफिकेशन ऑफ MPs एंड MLAs अंडर द RPA 1951, इसमें क्या क्या पॉइंट्स डाले गए हैं. एक तो प्रोटेक्शन ऑफ सिविल राइट्स एक्ट 1955 के अंतर्गत जो भी अनटचेबिलिटी के ऑफेंसेस में अगर कोई बंदा कन्विक्ट हो जाता है, तो दैट पर्सन, कन्विक्ट होना जरूरी है, मैं आपको बता दूं, ये नहीं कि आपके ऊपर केवल आरोप लग गए, कन्विक्ट होना जरूरी है. तो प्रोवाइड्स फॉर प्रीचिंग एंड प्रैक्टिस ऑफ अनटचेबिलिटी, कन्विक्शन इज नेसेसरी फॉर डिस्क्वालिफिकेशन. सेक्शन 11 ऑफ कस्टम्स एक्ट, जहां पे आप इंपोर्ट एक्सपोर्ट कर रहे हैं प्रोहिबिटेड गुड्स का, ठीक है ना. सिविल राइट्स एक्ट अनटचेबिलिटी के लिए, कस्टम्स एक्ट इंपोर्ट एक्सपोर्ट ऑफ प्रोहिबिटेड गुड्स. अनलॉफुल UAPA 1967 के अंतर्गत, जहाँ पे आप किसी अनलॉफुल एसोसिएशन के मेंबर बन जाएं, लाइक जो कि किसी टेररिस्ट एक्टिविटीज़ में इन्वॉल्व है, ऐसी अनलॉफुल एक्टिविटीज़ में इन्वॉल्व है. NDPS एक्ट के तहत भी अगर आप किसी कन्विक्ट हो जाते हैं तो भी आप जो है 1985, तो भी आप जो है MP MLA की मेंबरशिप खो देंगे. एंड प्रिवेंशन ऑफ करप्शन एक्ट, ब्राइबरी वगैरह में, ठीक है ना. Prevention of Corruption Act for the offense of bribery, or if the person is convicted in the offenses related to corruption and being charged under the Prevention of Corruption Act 1988. And the offense of promoting enmity, if the person is convicted for promoting enmity between different groups on the grounds of religion, race, place of birth, residence, language, etc. Doing acts prejudicial to the maintenance of harmony of the state. Okay, so done any activity which is prejudicial to the harmony. Offense related to rape and sexual assault given in section 376 of IPC, or offense of cruelty towards a woman. Okay, so offenses like this, rape and sexual assault. He must not have any interest in government contracts, works or services. Okay, not interested in these contracts. Must not be a director or managing agent or hold an office of profit. I have already discussed, in a corporation in which the government has at least 25% share. So office of profit, and not a director or managing agent in a government company. In a company, not in a, only in a government company, but also in a company in which government has at least 25% share. But he can be he can manage his own private business. That I assure you that private business is okay, but not government office or any office, any work in which government has at least 25% share. He must not have been found guilty of election malpractices or corrupt practices, and he must not have failed to lodge an account of his election expenses. So so uh, he must be uh, he must be lodging his election expenses or telling about the election expenses in time to the election commission. So he is not found guilty of election malpractices, and he must not have been failed to lodge his election expenses. So even after the election, every candidate has to file an affidavit with the election commission mentioning the election expenses which he has done during the election when he has fought election. That is mandatory. Otherwise, if he has become MP or MLA, he will be disqualified. He will fail to lodge it within time. Now here, if you one more point I have forgotten to mention here, that these points of disqualification have been decided by the president. So if the person is has become MP or MLA, then his disqualification will be decided by the president, but in the consultation with the election commission. So election commission consultation is required, but will be decided by the president. So president order is final, but in consultation with the election commission. So this is very important for your exam. So in the next lecture, I am again taking a very small topic and again delivering you a lecture, so that it will be easier for you to understand different topics in a simpler and easier way. Okay, till then, wait for my next lecture, and kindly like my lecture if you like it, and share it to as many people as possible. Thank you.